Well, hello everybody. Welcome to another great edition of Coffee with Michael. Today I have Renee Noy back with me. Again, just such a trooper. All I have to do is just reach out, and she says, "Yeah, we'll find a date. We'll make it work." So again, for those of you who have not had the pleasure of hearing Renee on any of the webinars or the previous podcasts that we did, Renee is a partner with Workwise Law. She's one of the founders. She's been practicing for over 20 years. She worked a number of years at a prestigious plaintiffs law firm. We're not going to hold that against her. Or she became proficient in representing plaintiffs against large corporations. But over 10 years now, she's been on the employer side, which is really good because now she knows, I don't want to say tricks, right? But they know where employers have fallen short. So as a plaintiff attorney, she's able to really focus in on those areas. So now we can get the benefit of all that experience. She has worked in a lot of cases involving disability, race, gender, and age discrimination, sexual harassment, wrongful termination, and a variety of wage and hour disputes. So first and foremost, good morning, Renee, and
Good
welcome
morning.
back.
Thank you. I appreciate you having me back.
No, always good to have you. All right, so today is going to be on leaves of absences, but it's not the boring nuts and bolts of it, right? So for FMLA, do you have 50 employees and 1,250 hours? We're going to take some of the questions that I've received, and I'm going to lay it out for Renee and to try to get her response. Now, again, it's very important. Renee is a wonderful attorney, but nothing in this podcast is to be considered legal advice because we're going to talk about a lot of shades of gray today. It really depends upon your specific circumstance. So if you have something come up, Renee's information is in the email where you got this link. So please make sure if you do not have an employment attorney, if you're not pleased with the employment attorney you have, reach out to Renee and her team. Her firm is growing, so I know things are going well. I've also recommended Renee and her partner Alexis to a number of my clients already who were just thrilled with what they've been able to do for them. So with that being said, so leaves of absence are probably one of the most difficult things we deal with. For me, complications, right? I've been in HR, I mean, well over 25 years now, and even now, when one of my clients calls me, potential leave of absence, we always have to go through the steps, right? In my mind, it's the okay, how many employees do you still have, and how long has this employee been there? Boom, 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 boom. But we can do the nuts and bolts of it. But then one of the weird questions come up, and the one I sent to you had to go out, and I get this regularly, so I'm really glad we're able to talk about this. So if an employee is struggling with something, at what point, well, let's ask it this way. If an employer thinks the employee needs to go out on a leave of absence, what should they be looking for? How can they approach it? And at the very end of it, are they able to say, look, we're going to put you on a leave of absence? So if so, what would that look like?
Okay, so that's a really good question. I
We're
deal with
starting
it.
with an easy one.
No, it's a good question. I deal with this all the time
Yeah.
with my clients. And so I always tell my clients it's really a song and dance that you have to go through. And you have to have a lot of patience because this is a dance that can go on for a very, very long time. And if you get frustrated and decide, you know what, I can't do this anymore, and you decide to just terminate, or you stop the communication, then you're truly just walking yourself right into the door of a lawsuit. And then what I tell my clients is as much as you didn't want to deal with them as they were an employee of yours, think about how you're going to feel when they're on the other side of a litigation. Like you're dealing with it for 2 to 5 years sometimes. So you really want to be able to deal with this properly. So the number one thing to remember anytime you're dealing with these issues is to keep the communication open. So if all of a sudden, if you have an employee and they have a job and they're performing their job responsibilities, and all of a sudden you see them slipping through the cracks, so they're coming in late more often than they used to, or they're missing a lot of days and they're calling in and just saying, I wasn't feeling good or something was going on, then it's just important to sit them down and just say, what's happening? You know, you're not responsible or liable for anything unless you have knowledge. But you have to really try to get them to talk to you. You're not a doctor. And even if I have plenty of medical clients that they really are doctors, but
Yeah.
unless they're a specialist in that field, you're still not their doctor and you don't know exactly what's going on with them. So don't start prescribing, don't start diagnosing, don't say, well, you clearly have this issue. My aunt had that, so now we're putting you on a leave. it needs to be very much a open dialogue where you say to them, I'm concerned, keep it always about the performance. Like that's the best performance, or if they're not being reliable and accountable in terms of their showing up to work. So you want, that's what you really want to focus on. Your performance has slipped. Why? What's going on? You've been out more and more days lately. Why? Is there something that I need to know? And ask them. And if they say to you, you know what, if they say, no, I'm fine. It's just things have been, just difficult. Like just, I'm having a hard time with my work, but I'll be okay. Is there anything that I can do to help support you? If they say, no, I'll be fine. Well, that's great. So now you can hold them to the standard of any employee. And the next time they slip up, you write them up. And if they slip up again, you write them up again, or you terminate them. As long as you don't have knowledge, even if you have an inkling that maybe something's medically wrong with them, unless it's obvious objectively and really obvious to a non-medical professional, then you don't want to treat them as a medical issue and just treat them as any employee. But if they say to you, when it gets complicated, they say, you know what, yeah, I've been really struggling. I've been really feeling bad lately, and my stomach's been hurting, or I've been getting these headaches. I don't know what's going on. Then say, okay, I'm so sorry. Do you want to get a doctor's note? Do you want to take a leave? Ask them. And if they say, no, I'm fine, say, okay, fine. But if they start to really slip up and things are getting really bad with their performance, or they're really just not showing up to work, at that point, you could say, listen, you've already indicated to me that you're having some medical issues, your performance is not improving, your attendance is not improving, you're taking longer lunches, whatever the case may be. I think, in order to continue work, I need a doctor to tell me that you're okay to work. And if they usually at that point, they're not going to fight you. So now they go get a doctor's note. The doctor puts them out on a leave, fine. Or they'll have some accommodations. She can work, he can work, but he needs to only work part-time schedule twice a week so he can relax at home. I always tell my clients, like, you don't have to move mountains for your employees, but you kind of do have to move mountains for your employees. So you really, the ability for you to accommodate your employees, it's a very, very high bar. So you really need to make a lot of effort to try to accommodate your employees.
And it's a difficult dance, like you said, because again, you don't want too much information. So if you sit down with the employee and say, hey, we just want to make sure everything's going on. Should you preface this by, look, if there's something medical, we don't need to know specifics. We just need to know if you need some kind of accommodation that we need to discuss. So,
Yeah.
but you should really preface it, because you said, you don't, there's things you don't want to know. And I think that's going to be one of them. So would you say that that's a good way to approach it? Say, look, we're concerned. We think there may be some kind of medical issue. We don't need to know specifics. Please don't give us specifics. We just need to know, is there something you need assistance with? And
Yeah,
then you
I
can
mean,
kind
if
of take it down
if
that
they
road.
indicate some sort of, if they even infer that there might be something medical going on, then and if they say, you know what, I'm just not comfortable talking about it, say, listen, I'm not here to get your diagnosis. I'm not entitled to know your diagnosis, nor do I want to know.
Yeah.
But all I need to know is that you're okay to work. And I don't, and make it, always try to make it about them and not about you. So you don't want to say, I need you to work. We have all these deadlines, things are coming up. You never want to have it as that tone. You want to say,
You're failing.
what's
Yeah.
that?
You're failing.
Yeah,
Yeah, that's not a
exactly.
good thing.
You're costing the company money. You never want to say that. It's like, I want to make sure that you're okay to come to work every day, that you're able to sit down and do your work. And if there's anything that you need, like, we need to understand, because we don't want you to, if there's some sort of restrictions or accommodations that we need to provide, like, we want to make sure that we're able to give that to you, but we can't do that if we don't know. So you don't need to tell us what's going on specifically, but if you need to take some time, or you need us to give you some accommodation, we need a doctor's note that supports that. And then the dance really comes in with, all of a sudden now they have a doctor's note that puts them out on leave for 6 weeks. Well, what do you do after the 6 weeks are up? And then,
Yeah.
as long as you keep getting, you have to continue the communication. And then as the communication continues, and then you find out a couple days before, you write to them, okay, we're looking forward to having you back at work on Monday, just checking in with you. And then all of a sudden they just send you an email back with another doctor's note, putting them out for another month and another month and another month. I mean, it's very frustrating, but just recognize that, at that point, they're not on your payroll anymore. And
Right.
they're in your system, but they're not on your payroll. They're getting their money through disability. So it doesn't, I always tell my clients, this is not costing you anything. It's other than, the 12 weeks of continuing their paying your contribution of their
Health
premium. But
insurance.
other
Yeah.
than that, it's like, just play the part and do what you need to do in order to avoid a lawsuit.
All right. So let's talk about doctor's notes. So if the employee says, no, I'm fine, then that's fine. You don't have to go. You say you're fine, just document it really well and make sure that you're holding them accountable to the same standards as everybody else. But what if okay, so fit for duty, right? When So if an employee brings a doctor's note, again, one of the things I always recommend and encourage employers when you talk to the employee, say, okay, you're going to go get a doctor's note for us. What we need to know is what kind of restrictions you have, because we need to know if we can make a reasonable accommodation for you. And oh, by the way, here's a copy of your job description. You may want to show this to your doctor, and please make sure it's not just the responsibilities, but any physical requirements of the job as well would be helpful, especially for the doctor. So if you get something back and there are restrictions, but the restrictions really don't impact the job itself, they should be able to do the job to the standard. So you so at that point, it sounds really cold and heartless, but you're saying, okay, we understand you're going through this. We're really sorry you're going through this, but we still need you to hit this. Can they write up an employee, even if they have a doctor's note, even with restrictions, if the restrictions don't impact what the job requires?
So, so that's a really good question too. That doesn't happen very often because typically these restrictions are a nightmare for an employer to have to accommodate. I've never personally experienced a doctor's note that has such minimal restrictions that it's not going to impact the employer's ability to allow for the employee to continue working or for the employee to continue working. But here's how I would address that. This whole thing that we're talking about, it's really just a way of describing what an interactive process meeting is. And
Yeah.
having an interactive process, a failure to provide an interactive process is a cause of action that's in the Superior Court all the time. And so you have this obligation to do this interactive process, which is really a fancy word of just saying having a conversation. So if the doctor comes back and there's restrictions that say can't work overtime and they can't travel for work and they
Yeah.
can't, they have to sit down and you know it's a desk job, it's an 8 hour job and they never travel. You're like, oh, easy peasy, like this is nothing. So what I would do is I would bring the always, no matter what, whether they're ridiculous restrictions that are impossible to accommodate or the easiest things in the world, bring the employee in when they give you the doctor's note and say, thank you so much for providing this to me. We're going to keep this for our records. We'll give you a copy, but I just need to understand this is what the restrictions state. This is what your job description is. From our read of it, this is not going to be very difficult for us to accommodate. Is there anything that you want to, bring up as a concern of yours, or are you okay doing the job? And if they say, no, I'm totally fine, that's great. They say, well, I didn't really explain it to my doctor that I also need to, take a break every half an hour. And that wasn't really stated, but I do feel like I need to do that. What you can do, if you get them to sign off an authorization that allows you to talk to their doctor, you can say, let's talk to your doctor together. They sign off an authorization, sit down, call the doctor together, and just say, okay, I just want to be clear. We gave you the job description. This is what the employee is saying is that they also need to take these rest breaks. Is there any reason why you feel like that's the case, or is there anything else we need to know? You can get clarification from a doctor if it's not obvious. Don't be afraid to do that, but of course you do need to get their authorization to talk to the doctor. You can't just call a doctor.
Okay. Yeah, because that was one of the questions I was gonna have for you. So what if the employee does or actually, before I go there, I've actually had in the last year and a half about 4 or 5 clients call me with that. The doctor's note comes back, the employee can still do the job and should be able to hit those metrics, but he or she, I don't want to say they're trying to play on sympathy, but they're really milking this thing.
Yeah.
And so at that point, again, it just comes back down to sitting them down, saying, well, look, your restrictions don't really impact it. We need you to be able to do to just document the heck out of everything.
Yeah, I mean,
Um,
you're only beholden to whatever the doctor tells you. So
yeah.
if the doctor doesn't say, and you're also allowed to make, 20 mistakes on everything that you're submitting, and there's nothing neurological happening, then you could say to them, look, this isn't working. Your restrictions are not giving justification for the things that are still happening. Do you need to take another medical leave? Like, is there something else that we don't know? Like, just again, it's all about keeping the no, I've never experienced any disability discrimination lawsuit where the employer is continually talking to the employee. And by the way, like of everything we're talking about here, the most important thing that you need to do during this whole process is document all of your conversations. Every
Yeah.
time the employee leaves their office, send an email. Dear John, thank you so much for meeting with me today. Per our meeting, here's what we decided. Here's what was discussed. Because if you don't have that, then you're going to be like, look, I did everything. I talked to this guy all the time. We had all these meetings. We were completely on the same page about everything. And he's like, I don't even know who this person is. We never talked ever once. So
Prove
it's
it.
your against theirs. So you want to document everything. It didn't happen unless it's documented. Remember that.
Okay. All right. So, see where are my other notes? All right. So let's just jump into process then. So if the employee, let's say they do come back and they're able to do the job, right, with the restrictions that they have, but they still struggle for whatever reason. Maybe they're just again trying to milk it. Maybe there is something else they weren't honest with the doctor. At what point can the employer say, okay, we you're just not getting enough done, right? And even with a reasonable accommodation, there is no reasonable accommodation. You need to do these things, and you're the only one in the department, or whatever the reason is. At what point can the employer say, we are going to put you on a leave of absence, or is that even a possibility?
So if you bring it up to them and say, look, the work is still not getting done to our satisfaction, you're still not meeting the requirements of the job, ask them again, what is going on? And if they say, I don't know, I'm doing the best I can, say, okay, that's fine. Say, so you're okay. Like there's no reason to do a follow-up. There's no medical issues that we need to deal with. And they're like, no, I'm fine. I don't, I think you're just asking too much of me. Fine. So then what I would suggest before you throw them onto a leave is put them on a performance improvement plan and then just say, is there a reason why when you present it to them, which has all of the goal, the job, the responsibilities that you expect them to do, all the places where they're falling short, and then specific goals of what they need to meet. You follow up with them every week for at least 30 days. But ask them when you present it to them, look, this is not working. And I know, we know we've created some accommodations for you, but putting those aside, you're still not doing the job that we're asking you to do. You're letting us know that there's nothing else going on. So we're going to give this to you. Is there any reason why you aren't able to be under this performance improvement plan? And then if they have something legitimate, okay, well, I haven't told you about this other thing I'm dealing with. Okay, fine. Now you have to deal with that. Or if they say, okay, that's fine, I'll go on the performance improvement plan. Once that's happened, then and they still are not living up to the expectations, then you can terminate.
Okay.
There's only so much you can do for an employee. It's like if they have a
Yeah.
medical issue, you have to
Yeah.
accommodate. If you've accommodated and then that's all been handled and they're still not performing, you don't have to keep them forever.
So would it be worth it then? Because again, FMLA, CFRA, they have intermittent leaves. So if you're dealing with somebody where the restriction may be coming from the doctor that look they can do the work, but like you said, they can't work overtime. To me, that would be a legitimate restriction, right? You can only be on your feet, you can only be up for so much time. So if again, my recommendation, get the stuff out at the very beginning, right? You always tell them all their rights. We're kind of getting into the process stuff now. Give them the brochures, talk to them about the leaves of absence, what their rights are. But if you're going to put them on any kind of an intermittent thing, and we're not talking about duties now, it's just time. Um, I'm constantly getting calls from clients that, yeah, we've been working with them for the last 6, 8 months, sometimes 3, 4, whatever, or excuse me, 6, 8 weeks, or sometimes it goes into the months. And then they say, well, now they kind of want to go on a full leave, but they should have started at the very beginning. If employers if employers do not start at the very beginning, can they make something retroactive? How far can they go back? Would you even recommend that, or just draw a line and say, okay, we're going to start now, and here are the 12 weeks begin?
I think it's safer. I mean, it's really your job as the employer to be on top of all of this. It's not their job to say, okay,
Yeah.
now I need to take my FMLA leave. They don't know, so it's really your job to be on top of it. So if you've kind of like not handled it properly because you're just kind of dealing with the fires as they're coming and have a doctor's note here and there and trying to create some accommodation, but you haven't really sat down with them, then you can't go back and say, okay, actually now, I mean, you wouldn't be able to retroactively do a FMLA leave in the context that you're describing because it's not wage replacement. It's just job protection. Disability you can apply for retroactively. But if there's, that's a really hard question to answer without knowing all of the
Yeah.
specifics. But you're right, you could do intermittent leave, but I just to be safe, I mean, I always would err on the conservative side because these are just such litigious areas. So I
Yeah.
would rather just sit down with them and be like, okay, look, we've been trying to work with you. Nothing is getting fixed. You're still, we've been creating all these accommodations. Maybe now it's time to talk about putting you out on a leave. But again, you're not the doctor. You're not the one that has the control or the ability. It's up to the doctor to say, yes, this person needs to take a medical leave.
Okay. All righty. Okay. I've I've kind of hit the end of my questions. I just kind of want to throw it over to you as far as is there anything we missed? Anything that you thought about that they should probably hear this? And just talk about the importance of process. I mean, you touched on it a number of times. I always touch on it, but to me, this is the killer. Um, because they don't start properly at the beginning, they don't get the letters out, they don't get the information out, then they try to play makeup at the end, and it blows up in everybody's face. So
Yeah. Well, it's really a matter of the open communication, documenting everything, and just really making sincere effort to try to figure out how to get this, how to keep this employee employed, to continue their employment. So, I say this all the time in different contexts, but employers that really, even if you don't really care, because look, from all of my clients' perspectives, so many of them are like genuinely, most of my clients are genuinely really, really good people that are
yeah,
really just trying to do the right thing. But you're not in this to take care of people. You're in this to run a business.
yeah,
And so all of a sudden you find yourself as someone who's managing an operation that's really, really complicated and dealing with all of these annoying employee issues that you really don't want to deal with, that you didn't really sign up to deal with when you started this business. You didn't even think about it. And now it's like you're playing like let's play nurse, where it's like, are you okay? Is there anything we need to
yeah,
do? And it's frustrating. It's really, really frustrating. So I have so much compassion when I deal with this issue with my employers, because it's like, if you don't feel good, stop working. Like, why do I have to manage this? Like, we're all adults here, but you do. I mean, the laws are so designed to protect those employees, and you
yeah.
really have to bend over backwards many times in order to make sure that you are complying with the law. So you're kind of stuck. And so as long as you really just like, if you meet this task, this challenge with the patience that's really necessary, the care, or at least the pretend care that you really do like, and the ultimate goal should be, how do I make sure this employee stays safe, that they're okay, but they're able to continue their job here? If you go in with that mindset, you'll probably end up dealing with it the way you're supposed to be dealing with it. So yes, you do need to know when CIFRA applies. If this person's been with you for a month, you don't need to put them on a CIFRA or an FMLA leave. They're not eligible. So you do need to understand all of that. But really, as long as you just talk to them and get doctor's notes, and don't diagnose them, and don't you don't tell them when they're ready to come back to work. You don't tell them when they need to go out on a leave. You're not a doctor. And even if you are a doctor, you're not their doctor. See,
Yeah.
so that's what you really have to remember. That should be the takeaway of today's podcast.
Okay. One last question, kind of off topic, but kind of similar topic. The doctor's notes and just sick pay. It's illegal to require a doctor's note when somebody takes a sick day, right? If they got the time, they're taking it, just can't do it. But at what point, if you were concerned, if they are 3 or 4 days in a row, and you're concerned that they may not be fit for duty coming back, right? It may be more than just the flu. Are they contagious with something else? Did something happen to them where there are restrictions that now you need to be aware of? Is it ever safe to tell an employee, hey, look, before you come back, we are concerned for these reasons. We just need a fit for duty to make sure that you're not contagious to anybody else and you're not going to do more harm to yourself. What?
Well, fit for duty, that it's a little bit of two different issues, because fit for duty is its own universe. Like, that's its
Something.
own podcast. Because fitness for duty is like, you can absolutely send somebody for a fitness for duty test so that they get evaluated. It's under very, very limited circumstances that you can legally do that. So I would not do that without talking to you.
Well, I think I might be just using the wrong language in because I just want to make sure that they're not going to come in with something that is
So
contagious
right.
and
Well, so
yeah,
that's tough. I mean, in flu season and COVID season, like, it's tough. Like,
yeah,
employees do get sick, and and they might have already utilized all of their sick time and they have nothing left, and they're like, well, we can't not work, so they come in sick. So if somebody is coming in and they're just like, snot coming out their nose and they're coughing and coughing up lungs and they're just obvious, their eyes are red and they're just like glossy, then you could say to them, you know what, like maybe it's better that you just either take a sick day or work from home or come in tomorrow. You can do that. But if after, I mean, each company has its own policy. So, I mean, a lot of our clients have policies where after 3 days of being sick, in order to excuse it as sick leave, you have to come in with a doctor's note saying that you are okay. But usually, if somebody's like contagious, you can usually tell. So if you walk by somebody's office and they're sneezing like crazy, you can send them home and say, you know what, like you're clearly not healthy. You're something's going on. We don't need the entire office shutting down because everybody gets sick. Please go work from home. So you
So
can
you
do
can't
that.
send them home. You can just say,
If
look,
somebody
you're
is
sick.
obviously falling apart on you,
Just
yeah,
document it, what you see and what you
yeah,
hear. Okay.
yeah.
All right. All right. Fun stuff. Fun stuff. All right. All right. So fitness for duty. Since you offered, I'm going to talk to you. I'll send you some information and let's talk about that because I think that would be a fun one as well. And
Yeah.
definitely necessary. But Renee, as always, such a pleasure. Thank you so much for all your expertise.
Thanks, Mike.
And any last minute words of wisdom for the group?
Just pretend like you care. Act as if you care and document everything.
Okay.
Those are the best pieces of advice I can give.
Yeah. Stand in front of the mirror every morning and practice smiling. Okay.
Yeah. Yeah.
All
No, I
righty.
mean it really goes a long way. I mean, I
It
did
does.
work on the plaintiff side, like you said, for 13 years. And I say this all the time in my lecture. I'm sure I've said it in this podcast, that employees who felt cared about and felt valued and treated properly, they're not the ones that go and sue you. It's the ones that just felt like they were dismissed, that they didn't care. They come in, they have a doctor's note that says that, they need all these accommodations. The employer's like, I don't have time to deal with this, requiring the same things of the employee that they always required. Those are the employers that get sued. So
Yeah.
really just really making sure that you have that open dialogue and doing what you need to do. It's the best interest of the employee. That's the bottom line.
Yeah, I'm going through a Gallup study right now that just came out on leadership and what employees need from their leaders, and compassion and empathy is high on that list. So,
Huge. It's
all
huge.
righty. Well, hey, I think we've done this one. So thank you very much. You have a
Thanks, Mike.
wonderful rest of the week. And everybody, again, if you need a good attorney, get her information from this email. Thanks so much, Renee.
Thanks, Michael. I appreciate it.